Good afternoon, everyone, and welcome to this 30-minute lunch webinar co-organized by the Climate Governance Malaysia and Q&Co. I see, we have people joining in already. The numbers of participants are shooting up steadily. So, welcome again to this 30-minute is a quick lunch webinar session. So I'll get cracking because we're right on the dot now. So in this quick session, we are going to share some preliminary responses from the three panelists today on the landmark International Court of Justice's advisory opinion that came out on 23rd of July 2025 on the state's obligations in relation to climate change. All right, and we will focus where we can on what that would mean to businesses in Malaysia. So by the nature of such discussions, there are great limitations to the scope and the depth of our analysis, how far we can go. And so if you are interested in more related discussions, please send us your feedback to CGM, and I'm sure they will respond to it. They will listen. Right. And here's an important disclaimer that none of what we say today should be relied upon as legal advice. Yeah. If you should always consult your own lawyers when deciding whether to act or not to act in your particular situation. All right. So who will you hear from today? We have three discussants and panelists. I'll start myself since you're hearing my voice now. My name is Kiu Jia Yaw. I'm a sustainable development lawyer from Q&Co. I'm wearing two hats today. So one as the moderator and then later on as a panelist. Next, we have Elizabeth Wu. She's a legal consultant with the international environmental law NGO, Client Earth. And finally, we have Tan Sri Tommy Thomas, who was the former Attorney General of Malaysia between 2018 and 2020. All right, welcome everyone. Let's get started. And I cannot think of anyone better to set the scene for us on what is the International Court of Justice and the advisory and its advisory opinion than Tan Sri Tommy Thomas. Tommy, over to you now.
Yes, I thank CGM for inviting me to speak on this welcome development in public international law through ICJ's judgment on the 23rd of July, which was about 3 weeks ago. What I propose to do is to spend a few minutes on the judgment in order to set the scene for the discussion that would follow. The ICJ receives or assumes jurisdiction in a number of ways. In this case, it was by way of an advisory opinion. Although it's not legally binding, the judgment represents the latest judicial thinking of judges from many jurisdictions representing the major legal systems across the globe. So its importance cannot be exaggerated. So the background is this. On the 29th of March 2023, the UN General Assembly adopted a resolution requesting the ICJ to render an advisory opinion on states' obligations under international law regarding climate change. That resolution was through the co-sponsorship of over 100 countries, but the background, the real heroes, is the grassroots movement in the island of Vanuatu in the Pacific in 2019. It began there. And the two questions that were posed by way of that resolution are the following. First, what are states' obligations under international law to ensure protection of the climate system and the environment from anthropogenic greenhouse gas emissions for present and future generations? And secondly, what are the legal consequences if a state, by act or omission, causes significant harm, one, to other states, especially small island developing states and vulnerable countries, which explains Vanuatu's role, and secondly, to peoples and individuals of present and future generations. Although this was, in a sense, an ex parte application, there's only one party, the hearing was remarkably well spread. There were 91 written statements, 62 written comments. There were 96 states that were involved in one way or the other, and 11 organizations made oral submissions. And the hearing went on from about the 2nd to the 13th of December. about 10 days. So they had full argument. And in July of this year, after about 7 months, the ICJ delivered its advisory opinion. And this opinion was adopted unanimously by the judges, which is quite unusual because apparently this is only the 5th time in ICJ's history that they've reached a unanimous judgment. The key findings on the obligations, if I take obligation A first, were the treaty obligations. The judgment said that under the United Nations Framework Convention on Climate Change, there's an obligation to adopt measures with a view to contributing to the mitigation of greenhouse gas emissions and adapting to climate change. And then the states must cooperate with each other. Secondly, under the Kyoto compliance, the court said that there must be compliance with specific emission targets. Then the Paris Agreement, what the states must do is to prepare, communicate, and maintain successive and progressive nationally determined contributions, which inter alia, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5% C above pre-industrial levels. Secondly, to pursue measures which are capable of achieving the objectives set out in their successive nationally determined contributions. And finally, adaptation and cooperation, including through technology and financial transfers, which must be performed in good faith. And then they also accepted under customary international law, there must be an obligation to prevent significant harm through due diligence and to prevent harm from activities within jurisdictions. And of course, there's always an obligation to cooperate in good faith. They also accepted that under human rights law, there is a duty to ensure enjoyment of rights through environmental protection. So those were the obligations. And then what are the consequences? And this is what the court said. A state that fails to meet its obligation commits an internationally wrongful act. And the legal consequences include cessation of wrongful conduct, assurances of non-repetition, and full reparation, which includes restitution, compensation, satisfaction, provided that the general conditions of the law of state responsibility are met, including that a sufficiently direct and certain causal nexus can be shown between the wrongful act or injury. Now, I need to, with the time running, can I read a quote from the president of the court? It is Justice Yuji Iwasawa. And of course, all of them were lengthy judgments, but I thought this quote of the president epitomizes the problem. And if I quote, however, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political level to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come, unquote. I think that's my time allotment. So if I could end with that quotation. Thank you.
Thank you so much, Tan Sri. Thank you. And Elizabeth, over to you for your interventions now.
Thank you so much. So let me start off by thanking Jia Yaw and CGM for the opportunity to take part in this lunchtime presentation, and also to make the quite strong caveat that all comments I'm making in my personal capacity. So I'll be making comments with respect to implications for global climate litigation. I want to make 4 basic points the kind of impact that the ICJ advisory opinion will have. The first is potential increase in litigation by private actors against governments. So as Tan Sri Tommy Thomas has outlined, this advisory opinion has affirmed that all states have an obligation of due diligence to prevent significant harm to the climate system, and it's a definitive interpretation of states' obligations under existing international law, including the United Nations Framework Convention on Climate Change, the Paris Agreement, and customary international law. So given that there is an essential interest in all nations in safeguarding the climate, which the court remarkably framed as obligations erga omnes, as we say in legal terminology, this gives climate litigants a much stronger legal foundation to argue that government inaction or inadequate climate policies constitute a breach of international law. And at the same time, the court's focus on the 1.5 degrees Celsius target makes it difficult for states to justify climate policies that are inconsistent with this target and provide a benchmark for potential legal challenges. The second implication is increased litigation against corporations. And this is because the advisory opinion will have a cascading effect on the corporate world, because governments must now translate their international law obligations as articulated by the ICJ into domestic rules and policies, as well as increase regulatory enforcement of existing rules and policies. So as states face increasing legal pressure to regulate emissions, this will translate into regulatory developments and changes for corporations, and the opinion can also be used to support lawsuits directly against high-emitting corporations by arguing that their activities contribute to the violation of human rights and environmental laws. Tan Sri Tommy Thomas has also articulated how the ICJ has linked the issue of climate change to human rights, and this potentially opens the door for a new front in climate litigation because we potentially could see an increase in cases arguing that the government's failures on climate change violates the human rights of its citizens, particularly the rights to life, health, and a healthy environment. To the extent that that translates into regulatory changes for corporations, that also affects the way that corporations will be expected to respond and deal with the interface between business and human rights as well. Another aspect potentially is the increase in cross-border litigations against corporations, particularly parent companies. So the advisory opinion reinforces the duty of states to regulate the activities of private actors within their jurisdiction, and this provides a boost to what we call home state litigation, so litigation where the parent company is located for the environmental and human rights damages caused by its subsidiaries or supply chains abroad. And we can see an increase in cross-border litigation. You would potentially have the case of Holcim, the company being sued in Swiss courts for climate impacts that are occurring in Indonesia. You also have potentially issues of piercing the corporate veil, issues of assumption of responsibility, and to the extent that the ICJ's opinion strengthens the argument that the home state has a positive obligation to prevent its corporations from contributing to climate harm overseas. This all has an impact in bolstering transnational litigation and requiring stronger types of transnational governments among states as well, because the ICJ opinion also articulated that states have a duty to cooperate with each other to deal with the issue of climate change. Another aspect I want to highlight also is the potential impact on investor-state dispute settlement. Now, the International Court of Justice did indicate that international investment law can be relevant in the context of climate change. And this is important because it potentially allows states to use the content of the advisory opinion, the pronouncements by the ICJ, as a shield in defending against the kind of lawsuits that foreign investors can take against them, because they now can say that their climate policies, if they can show that they're in alignment with the pronouncements by the ICJ advisory opinion, then that can potentially provide a kind of modified form of way to respond to investor action that's taken against them. And this also could potentially force a reevaluation of traditional investor protections, such as fair and equitable treatment standards or protections against indirect expropriation when they conflict with climate action. At the same time, unfortunately, in my view, the ICJ opinion did not potentially go as far as it could have to deal with the interface between international investment law and climate change in the environment, because it was a missed opportunity for an explicit call for a redesign of investment treaties to align with climate obligations and human rights. And this contrasts with the more direct approach of the Inter-American Court of Human Rights advisory opinion, which was rendered a couple of weeks before this particular ICJ-AO. So this is certainly an evolving space, and interesting to see how these issues can develop. So I think finally, and just very quickly, because I am very badly out of time, I think the recognition also that there is potentially going to be increased litigation between states, because this is in line with the principle of common differentiated responsibilities and respective capabilities. So the degree of care that is as expected of a state with a well-developed economy and human and material resources will be different from that of states which are not so well placed. And this is explicitly articulated by the ICJ in its advisory opinion, to place increased responsibilities on more developed states. So it's interesting that the way that different countries around the world have responded to this, it's notable that the government of Fiji has actually stated that it would carry the opinion as a strong legal foundation to enhance climate action, support legal challenges, and shape the future of international climate law. So this does signal integration by some countries of the advisory opinion into the nation's diplomatic and legal strategies, and this could potentially increase litigation risk as between states. So I think I will just stop my comments there and pass the time back to Jia Yaw. Thank you.
Thank you so much, Elizabeth. That was really great. Great. You've covered amazing breadth of ground there. Thanks. Hopefully I can bring us back to some of these in our quick remaining 10 minutes later, as three of us discuss a bit more to unpack. So for folks, for my intervention in the next 5 minutes or so, I think my reflections are that as you've heard from Tommy and Elizabeth before, the advisory opinion has profoundly set the norm when it comes to climate action by a host of actors. Now, directly, the advisory opinion deals with states' obligations, so it does not touch directly on the private sector and private actors. However, as Elizabeth has spoken about, there is a cascading effect, and it will unfurl onto the private sector landscape very, very quickly. So the norm-setting aspect of it, I would say, sharpens the duty of care, the relationship between parties, right? It also raises or clarifies what is the bar? In other words, what would be the standard of that duty, right? And then it also lays down a lot of fundamental principles inside this opinion on principles regarding how to think about, how to analyze causation through that responsibility aspect, how to link the kind of harm that you suffered, the losses you suffered or stand to suffer with the unlawful actions, which include either active actions like continuing to issue oil and gas exploration licenses and permissions, or granting subsidies for fuel, such actions, or omitting to have put in place on the part of the government, omitting to have a reasonable or adequate governance framework on climate change. And so now I want to touch on that. The obligation, while it is universal across on all countries, it's important to note that the court said that it is not a one-size-fits-all. The obligation is, in that sense, contextual. It looks into each country's circumstances, as well as its capabilities and its responsibilities, right, in respect of climate change. And so it is a dynamic analysis in that sense. So a little bit very quickly about like where is Malaysia when it comes to climate governance. Yeah, Malaysia has recently revised its national climate change policy. It's called the National Climate Change Policy 2.0. That's a comprehensive policy framework that sets out all the strategic thrusts and actions that the government intends to take, with the key linchpin of it being the enactment of our first climate change law. And with regards to this, the climate change bill is now very close to being tabled in Parliament. Yeah, so the government in late 2024 has been conducting public consultation exercises regarding what the law is like with public actors on the non-profit side, academic side, and the private sector side. So from what we've seen so far, unfortunately, the government has not shared the actual text, so we do not know what is the depth in that sense, and also how is the proportionality in terms of focus areas. So that yet remains to be seen, but with the advisory opinion, I think the benchmark is set in terms of what ought to be expected, and that is a useful benchmark as well for Malaysians from a national domestic perspective to be able to assess whether this upcoming Climate Change Act will be adequate across all the areas that the Act should cover. Because as you would imagine, with the nature of this problem, the problem of climate change, the scope and the breadth of it. So if the law does seek to address all of it, from our international obligations to our government obligations, and then to translating that into how do we approach climate governance from a all-of-government approach. That means it's not just a single ministry's problem, but across all ministries, because it touches everything, and also an all-of-nation approach, meaning that we are not approaching handling climate change as a top-down, but a top-down as well as a bottom-up approach. So whether or not we do well in that will really determine how, for the private sector landscape, the climate governance framework provides enough clarity in order for leaders in the private sector to then set their respective visions within their, let's say, neighborhood of influence and responsibility. Because tied up with this, and with how tied up with this is this development that Malaysia is going to launch its National Action Plan on Business and Human Rights tomorrow. Yeah, so that will articulate how very clearly in terms of the nexus between human rights and businesses, specifically how businesses will need to and are expected to respect human rights in their operations. So I better stop here for now, and in the remaining 10 minutes, let us now go into a more free-flow discussions among the three of us. And perhaps, Elizabeth, can I invite you to get our conversation started?
Yeah, sure. Thanks so much, Jia Yaw. So actually, I have a pressing question which I'd like to ask Tan Sri Tommy, and that's what your views are on how international law interacts with the Malaysian legal system and some of the implications there.
Well, I think from a litigation perspective, that is how the courts approach it, it really depends on how the lawyers present the cases. And of course, when you're presenting a case, typically a lawyer would want to succeed. And there are different ways of succeeding, and he reads the judges and reads the court. So I would say as a starting point, hitherto there's been very little reliance by lawyers on public international law developments. So it begins with the bar. If the lawyer doesn't present many public international law arguments, then you can't expect the judges to respond. But on the few occasions, the barristers have put forward public international law submissions. Unfortunately, the track record is not very favorable. The judges typically in Malaysia prefer, even if they are on the side of the person putting forward the argument and he succeeds, the courts would try to justify that decision by domestic legislation, and particularly our constitution. And we've got fundamental liberties and part 2 and freedom of speech and right to the environment and whatever as judicially interpreted. So briefly, the track record so far has been not much, but it can only improve. And I think the challenge, the call is to the bar, to the lawyers, to keep presenting the arguments. And then hopefully over time, the judges are influenced.
Yeah, thank you. Thanks, Tommy. So really the lawyers have to step up to this new demands, and then as they do, then the judiciary too have to keep up and really also be expand the capacity to dispense environmental justice and climate justice. All right, thanks. I see a question from Ahmad Azir, and I think it's a good one. Regarding what's our view on the SDG as developed in the Brundtland report, which is basically the really articulating the concept of sustainable development as development that helps us address our needs today without compromising the ability of future generations to meet theirs. So and yes, it is something that was core to the advisory opinion. Tommy earlier also alluded to one of the judges' passage, which talks about future generations. And in fact, intergenerational responsibility is a key principle behind this opinion, and demanding that the 1.5 degree limit really be adhered to in respect of that. Yeah, I see also. Anyone want to jump in quickly on the SDGs?
If I may, maybe I would like also to comment that the advisory opinion also affirmed the principle, the precautionary principle. So the precautionary principle is that where there are threats of serious or irreversible damage, a lack of full scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. And I think that has the overall effect of potentially strengthening the SDGs and providing an approach towards the way SDGs need to now be considered and implemented.
Yeah, thanks for that, Elizabeth. And yeah, Tansri, you have something?
No, I think if I can go back to the earlier statement, I was commenting about lawyers and judges, but it also one must not forget that litigation begins if there are clients and parties. So I'm sure you would agree with me as a litigation lawyer that in the branch of environmental law, compared to the 30 or other 40 branches of the law that make up the law of Malaysia, environmental law is one of those where, unfortunately, for litigation lawyers, unfortunately, there have not been that many challenges. So what we need is clients, parties, litigants, whether it's shareholders, people who are upset with things, whatever, civil groups, the Bar Council, whoever would be interested in environmental issues to bring forward environmental litigation. Because unless there is environmental litigation before the courts, our law will not develop.
Yeah, spot on, Tommy. And on that, the Suhakam, our National Human Rights Institution, have published a report when it was asked to look at air pollution in the light of transboundary haze. It noted that the dearth of environmental cases actually going into court. It noted that there was a poor recognition of environmental rights generally per se. So people didn't know that they have the rights. Two is access to justice, especially environmental justice. Environmental cases are odd-shaped, and so they are difficult to go through the funnel to actually emerge through the doors of the court, especially for civil courts, because the criminal justice system is a very narrow way to look at environmental harm because it doesn't look at all the social and broader impacts to the rest of the environment. It looks very narrowly. So yeah, so thanks for that. Okay, I think we are at 12:59. I see some great questions coming in. Suganda asks, any thoughts on implications for company directors and their duties, right? And the evolution of ESG from merely voluntary to becoming mandatory. Yeah. So thoughts from both of you regarding directors' duties for climate action?
Sure. So maybe I'll just kick off. So yes, thank you so much for that question. It's a great question, and I do believe that the advisory opinion is potentially heralding a shift for the evolution from voluntary to mandatory requirements and standards. And of course, that therefore has implications on the kind of obligations directors have and the kind of obligations companies have. But I want to maybe highlight that this is not just a compliance issue. This is not just an issue of companies having to comply with changing regulations. The deeper issue for corporates is getting ahead of changing regulations. Regulation change that we can potentially expect to see in light of the advisory opinion and the kind of trend towards climate accountability around the world. And so it's very important for corporates to think of it from a competitive standpoint, right? To not be, to remain relevant and not be laggards. So I would encourage corporates to not just think only of litigation risk, but also legal risk. So get ahead of this before cases even emerge in the courts, as Tan Sri Tommy has articulated, right? So there's this is, I think, the potential gap that needs to be bridged in terms of understanding amongst corporates of the degree of pace of evolution.
Yeah, excellent. Thanks. Tommy, do you have something to add to that?
I think no company director in 2025, even before this judgment, and certainly after this, and the publicity hopefully that it generates, no company director in Malaysia can say that he or she does not take into account environmental factors and climate change factors in the decision-making process of his company. He sits at the apex of the power structure at the board, he or she, and they are discussing investment in decisions, risk decisions. They have to put climate and environment as one of the factors into the on the table. And of course, how much weight depends on the kind of industry. So if you're the oil and gas industry that you mentioned when we began, obviously, and climate change and environment is going to be so prominent.
Yeah, indeed. And unpacking both what both of you have mentioned, I think it's really important that what the role of directors, you're not all goalkeepers. You also have to play the entire field. So when it comes to climate action, you shouldn't just be focused on, obviously, as Elizabeth mentioned, you cannot all just be playing defensive and think, because adaptation isn't only about playing the defense. It's also about solutions and being innovative. And so as the business leaders will understand this very well, you cannot innovate if you're only trying to manage. Especially if you're just trying to manage risks, you cannot manage yourselves into climate leadership. You cannot manage yourselves into having a competitive edge in spite of the evolving landscape. So the directors' roles have becoming more demanding in that sense, and keeping up with what it means at these various levels, at the international level, the national level, and then at a subnational level. There's a question regarding municipalities, in fact, and I thought that was an interesting nuance, but I'm not going to take that because I think we are at 103. What I want to yeah, it feels like we're just getting started, but surely I think this we didn't intend for this to be the end. We want to invite people to actually put in your feedback about what else you would like. I'm sure there's more to unpack and to discuss. But before we end, I really want to invite Tommy and Elizabeth to give your parting words, a line or two in terms of just wrapping it up from you.
Well, I think since we are talking about the ICJ judgment, that's the principal reason for us meeting this afternoon. I think we should be inspired by their words, a lot of bold and stirring words to the entire global community. And certainly Malaysians should be inspired and just so focus on the environment and climate and try and do your best to improve it. And negatively not to engage in pollution and other activities. I think it's for each person to take on some degree of responsibility, and that responsibility is taken on with knowledge.
Thanks, Tommy. Elizabeth?
Yeah, thanks so much. I think I will have my last comment also be an answer to a question, because I saw Matthew's question about the interactions between the advisory opinion for the Inter-American Court of Human Rights as well as the International Court of Justice. My comment is really that the ICJ or advisory opinion is unlikely to be the last word on the matter. Rather, there is an overall direction of travel of increased climate accountability and action. And it's interesting that the Inter-American Court of Human Rights actually went even further than the ICJ advisory opinion in articulating the obligation to prevent harm to the climate as a use cogence obligation. So a use cogence obligation is basically an international norm that cannot be derogated from in any way, even by other treaties. And so this basically means that we can expect to see potentially even more progressive developments amongst courts and tribunals around the world that are inspired by the ICJ advisory opinion. And so once again, this goes towards the pace of the change in the current landscape. Thank you.
Thank you. And from me, I want to say that although it would feel the word that would come forward is, oh, this is overwhelming. Yeah, but the thing is, I think the moving forward is we need to approach this with partnerships and solidarity and collaboration. Work with, find your groups and networks. If you're a business, find your similar businesses together, even your competitors. Find your business associations, your chambers, the solidarity there. So it's like, hey, instead of focusing on like all the things you do not know, because there's so many things, because there's so many moving parts, but focus on what you do know, offer that. And when everyone pieces that, we're greater than the sum of our parts. So, you know, the efforts of networks like Climate Governance Malaysia is really crucial, because it's where we can, it creates these platforms where we can come together, we can highlight, hey, what are the issues at our respective areas? And then with that, we can see priorities, we can see patterns, and then we can start to frame problems better. So because you do not want to frame problems alone, because you have a lot of assumptions, you have a lot of unknowns. But when you come and you join and you take part and you get engaged, you start to find that you are taking leadership on your own, and you will be better and better at finding solutions, or at least partial solutions as you iterate your way forward. So I think there's a lot of value, and I'm grateful to CGM for what they do in this space. And that's a huge support to, I believe, the government as they too grapple with the overwhelming expectations. So that's from me. Now, I would like to just share that my firm is doing a seminar for a deeper dive into the ICJ-AO and its impacts in Malaysia. This is on an in-person seminar in 19th August in Kuala Lumpur. So registration deadline is on Wednesday, 13th. Now, next, the last thing, which is really, really important, is we want to, CGM wants to hear from you, and the topics that you have right now at the tip of your tongue, in the top of your head. Please send them by scanning this QR code that you see here, as well as the link in the chat. Your feedback, that richness, and so that the discussions, CGM will then can zoom in on specific areas and develop other events to address this. So this is for the post-event feedback survey. So what remains now is to thank Elizabeth, Tommy, and CGM. Thank you, everyone. Have a nice lunch.
Thank you, everyone.
Bye.
Take care. Bye.